Mr. President, I rise to offer this bipartisan amendment because I think a basic question needs to be asked at this unique time. Is it right when millions of law-abiding Americans are at home for their government to be able to spy on their internet searches and their web browsing without a warrant? Should law-abiding Americans have to worry about their government looking over their shoulders from the moment they wake up in the morning and turn on their computers to when they go to bed at night? I believe the answer is no. But that is exactly what the government has the power to do without this bipartisan amendment. I want to start by reflecting for a moment on how Americans are using the internet these days. They're helping kids with homework, checking out prescription drug prices for a sick parent, and they visit scores of different websites. In a pandemic, the internet may be their only connection to the outside world. So the question that we're presenting is, don't those Americans deserve some measure of privacy? Don't they deserve better than their government snooping into the websites they visit? How can this be that the government can spy on them when they're not suspected of doing anything wrong? And most importantly, how is this okay in America? With web browsing and searches, you are talking about some of the most intimate, some of the most personal, some of the most private details of the lives of Americans. Every thought that can come into people's heads can be revealed in an internet search or a visit to a website. Their health history, their medical fears, their political views, their romantic lives, their religious beliefs. Mr. President, collecting this information is as close to reading minds as surveillance can get. It is digital mining of the personal lives of the American people. Now, typical Americans may think to themselves, I've got nothing to worry about. I've done nothing wrong. The government has no reason to suspect me of anything. Why do I need to worry? Unfortunately, the question is not whether you did anything wrong. The question is whether a government agent believes they have the right to look at your web searches. In other words, without this bipartisan amendment, it is open season on anybody's most personal information. Now, there's a simple solution: require a warrant. With this amendment, the government can go to court and with a warrant collect whatever it needs from those who actually threaten the safety of our people. And in an emergency, something I feel very strongly about and have worked for as a member of the Intelligence Committee, the government can use emergency provisions, collect the information immediately, and settle up with the court later, proving once again, Mr. President, that liberty and security aren't mutually exclusive, that smart policies like this type of amendment help to get you both. Now, a brief explanation of how we got here. Right now, the government can collect web browsing and internet search history without a warrant under Section 215 of the Patriot Act. Section 215 from the beginning has been the most controversial and dangerous provision of the FISA law. That's because it is so extraordinarily broad and so vague. Under Section 215, the government can collect just about anything so long as the government believes it's relevant to an investigation. This can include the private lives of many innocent, law-abiding Americans. As I indicated, they don't have to do anything wrong. They don't have to be suspected of anything. They don't have to even have been in contact with anyone suspected of anything. Their personal information in some way, just has to be connected or relevant to what the government is looking for. Back in 2001, when Congress passed the Patriot Act, Americans were rightly concerned about their government collecting their library borrowing records without a warrant. My colleague, the President of the Senate, might remember, because this was nationwide. People were up in arms about the prospect of the government looking at library records, the books they borrowed, and the like. Well, I'll tell you something. What we're talking about here today, looking at web history, browsing, it is thousands of times more invasive of privacy than the library records that Americans were concerned about years ago. And there is, regrettably, a long history of abuse of Section 215. A few years ago, the government decided it could use Section 215 to justify the collection of every American's phone records. The government secretly decided that the phone records of millions of innocent, law-abiding Americans were again somehow connected, somehow relevant to something the government wanted. They wanted to get it without a warrant. It was only when this abuse was publicly revealed that Congress stepped in and began reining in the government's phone record collection. Now, the Supreme Court did determine recently that physical tracking of Americans as they move around requires a warrant. And in this bill, Congress is finally getting around to stopping the government from using Section 215 to conduct warrantless collection of certain location data. But the irony is, and I say this to my colleagues because of this unique time, the irony is, now that Americans have been asked to stay home and not move around so as to help our country fight this unprecedented contagion, they are more vulnerable to abusive surveillance than ever before. I think that's wrong. People today, whether they're in North Dakota, Washington State, Montana, Oregon, any of our home states, people are at home and they're living their lives online. Now more than ever, I would say to senators of both political parties, because I've long felt that these issues were fundamental to ensuring that we prove, as I stated earlier, that liberty and security aren't mutually exclusive, that smart policies give you both, and not so smart policies don't give you either. During this pandemic, Americans deserve assurances that the government isn't spying on them as their home, where they think they're going to have some measure of privacy, and probably until they heard this debate, didn't know the government could spy on them at home as they move around the internet. Americans deserve to know at this unique time that the government is not engaged in digital tracking of their personal lives. The warrantless collection of Americans' web browsing history offers endless opportunities for abuse. Donald Trump has called for investigations of his political enemies. Attorney General Barr has injected himself into investigations that affect the personal or political interests of Donald Trump. All it would take is for some innocent American's web browsing history to be deemed relevant to an investigation, and the government's off to the races, collecting all of that personal information. And then it wouldn't even matter whether that web browsing history had anything to do with the original goal of the investigation. For any number of reasons, the web browsing history of that innocent American could reveal potentially such embarrassing information that that person would be humiliated for years to come, and, of course, could be used against him or her. This is not a partisan proposition. Any administration, given the direction of the law absent this amendment, could be tempted to collect the web browsing and internet search history of political enemies, politicians, activists, journalists. And I'm just, before we wrap up, going to touch on some of the arguments against this amendment, because having served on the Intelligence Committee and followed these issues closely, invariably, at some point in this discussion, someone's going to come and say, this bipartisan amendment is going to be pretty much the end of Western civilization as we know it. We won't be safe. It's not going to protect our liberties. It's going to set up all kinds of arbitrary policies. And I just want to show how those arguments don't hold water. The first argument is that the government needs this information before it can get a warrant. But without web browsing history, there's still plenty of information available to the government even without a warrant. Phone and email metadata, subscription data, business records. But the big picture response to this argument is that it's Congress's responsibility to determine when some information is so sensitive that it requires a warrant in this bill. That was done with respect to geolocation information. I believe digital tracking of innocent Americans demands the same protection. And let me say, as I did earlier, when there is an emergency, and something that I have made a priority in my work on the Intelligence Committee, the government can go get the information immediately and then come back to the court later on and settle up. The other argument I imagine we'll hear is that this amendment would create protections for Americans that don't exist in the criminal context. The problem with that argument is that Congress isn't legislating on the criminal law right now, but it does have a unique opportunity to prevent intrusive surveillance of Americans and prevent abuses. Mr. President, FISA requires an extra layer of protection. That's because, unlike criminal law, FISA is secret. It's also a non-adversarial process. It relies on government representations that, as we've learned from the Inspector General, are frequently inaccurate. When the government uses FISA information against Americans, there's little or no notice or opportunity to challenge the surveillance. And most of all, it is subject to something that I have come to call secret law. Law that nobody knows about in a coffee shop in Washington or North Dakota or Montana. It's basically secretly interpreted, and as I pointed out on the floor in the past, warning the American people about these secret interpretations. Americans sometimes don't learn about them for years, and when they find out, they are really unhappy. So I want to just touch briefly on the amendment of the Senate Majority Leader, the Mcconnell Amendment. Not only is the Majority Leader trying to block the bipartisan effort that we've been talking about, his amendment would actually make the situation even worse. Right now, the government can collect the web browsing and internet searches of Americans without a warrant under Section 215. But so far, there has not been explicit congressional authorization for the government to do it. The McConnell Amendment would, for the first time, provide that authorization. The McConnell Amendment would, in effect, tell the government that Congress approves of the warrantless collection of Americans' most private information. Wrap your arms around that one. Congress explicitly approving of the warrantless collection of Americans' most private information when millions of Americans are sitting at home today in Kansas, in South Dakota, all across the country, sitting at home, believing that they have some expectation of privacy. The McConnell Amendment pretends to limit the collection of this personal information of Americans, but it's just a fake. What the amendment really does is meaningless. It says the government can't collect content, but no one knows what that means when it comes to web browsing and internet search history. There's no clarity in the statute. There's no settled law in the courts. The Supreme Court hadn't weighed in. So what the Mcconnell Amendment does is invite the Attorney General to produce yet more secret law, yet another secret interpretation, designed as these things always are, to allow for the collection of the broadest possible set of Americans' private information. At some point, Mr. President, I believe the Senate needs to focus on a little bit of history. Section 215 was secretly interpreted and abused in the past. The use of these authorities to spy on Americans' web browsing and search history is a screaming alarm warning us of future abuses. What the American people deserve and what this amendment provides is clarity and transparency about what the government cannot collect without a warrant. One last argument, and that is, we've heard if the Senate amends this bill, oh my goodness, the House just won't do anything at all. Well, there were 75 House Democrats and many Republicans. I want to underline that. 75 House Democrats and many Republicans who voted against this bill because it didn't include enough privacy reform. Adding key reforms like this amendment can only strengthen the support in the House. Mr. President, the American people will not tolerate warrantless government spying on their most private information when they find out that right now during a pandemic, the government has the authority to do that. I can't accept that level of unchecked surveillance. I'm very grateful for the sponsors that we have. They were listed by my colleague from Montana, a great array of organizations who share our view that liberty and security aren't mutually exclusive. I ask unanimous consent that a list of those organizations be entered into the record.
Without objection.
And we'll just say that I think right now, during a unique time in American history, when millions of Americans are at home and online, they deserve to have the United States Senate step up, defend their privacy and their constitutional rights, and protect them from abuses. This is the moment to stand up for those millions of people who have to be at home because we come together to deal with this contagion. I believe the Senate ought to pass the Wyden-Daines Amendment, oppose the Mcconnell Amendment, protect those people who are at home. And in wrapping up, Mr. President, I also want to commend our friends, Senator Leahy and Lee. As was noted, they have worked with us on a host of these efforts. I think they have a terrific amendment to strengthen the oversight role, the independent amici of the FISA court. I hope senators will also support it. I yield the floor.